One more chair right here.
Time to time that I got run this way.
Laura, are there more chairs still folded? This is it?
Are there any benches in the hallway? We used those last time.
We did use
put a
it.
bench.
The driver's license.
Where would we put a bench?
Well, like, next to find out.
Mark?
The whole people can figure it
What about the chair?
out. No, I don't want to touch somebody's stuff.
No, I don't either.
Whose is it?
I don't know. You can pull the benches out of the hall.
Yeah, he'll be wrong. And he'll come in over.
Do you want me to go do that?
What about that middle chair?
Never was that chair.
Oh, yeah.
I don't want to touch the
I
stuff.
was leaving that for you, Bob. I'm gonna call you and,
Using that chair.
Okay, sure.
yep.
I'll send this over here.
Where can it go? That's the question.
I suppose we could sit out in the hall.
Yeah. Except you can't hear out there at all.
Like you'd be able to hear there.
Yeah, I know. Is this thing going right now? Hi. It's me.
You could sing
I
right
already,
up, hello.
I already waved at it when I came through.
It's been going for 12 minutes. Hello.
It's me again.
You better not sing because I don't think we can afford
What's
rights.
that?
We
What's
can't
that?
afford rights of any songs on here.
That Adele one.
Might not be in and out.
Adele. So, our attorney. I figured since she was. Dying of heat. Sit out 5 minutes. Hmm? Yes.
Board of
Board of
Adjustment.
Adjustment.
Zoning smart. You're night early if you're here for zoning. For solar? Solar's tomorrow.
When did you?
They adjust things. That's the No, it has to go through Board of Adjustment, just the ordinances go through zoning. They're not reviewing ordinances yet, so this is an appeal to the building permits.
So the letter I got was from Tom.
I'm not sure what letter you got.
It said zoning.
Well, they just told us the zoning Board of Adjustment, which is a little confusing.
Nancy's already got it.
This is window, tonight is window. Tomorrow's solar. What are you doing? Bob has to get up again, we're in trouble.
Huh?
You won't be able to see her.
I probably took the chair.
Sit over there, I'll sit over here. Go over there. I don't want to be in the corner by Roger.
You have to sit by Roger. Huh? You have to put him with Roger.
I want to make sure.
Oh, shoot.
Don't worry, you catch me.
If you're here for wind, this is for wind.
Oh, that's right. He's pretty good.
What's Jim gonna say if I grab it?
Hey, Mike? Mike? Kurt Kelly is on the phone then. Okay, present on the phone.
We've got about 3 minutes to go.
About 3 minutes, Kurt. That's fine. All right, thank you.
Can't get in.
No, he's on the phone. She couldn't get us on the.
Oh.
Well, no. Yeah, everyone else on there. Are you good with that being there? Do you need me to twist this?
Do I do what?
Are you good with that being there? Do you need me to twist
No,
that?
it's fine.
What, they could put some right here. That'd be like those proceeding, right on top of the. Your mom said you went to that. Yeah, so she said, we didn't get to go. It was just too many things going on. Oh, yeah. Yeah.
Background.
Yeah. Yeah.
And then the picture.
Really?
I think it's mostly the house. And the girl who did Billy did really good too. She was stellar.
Oh, did I take that chair? I just realized what you're doing. I did it for you. I could have made you big trunk here.
Okay, folks, it's 6 o'clock. We'll start the meeting. We'll call the meeting to order. And a couple of the board members would like to address the crowd. Kelly? Or Nikki, I'm sorry. I was thinking Kelly's on the phone.
I just wanted to make a statement. I've been notified by our attorney that since my husband and I have a lease signed as a good neighbor lease with the Salt Creek Wind, that I might be in a conflict of interest. I just wanted to, I assume that people would think I would lean towards Salt Creek because of that. I would like to present a prior conversation that had taken place between Bob Bergstrom and myself. Bill Faircloth, our supervisor, was accused of having a conflict of interest when the turbines started coming about, and it was suggested to him that he recuse himself in matters of turbines since he also had a good neighbor lease with Salt Creek Wind. He was released from his contract with Salt Creek. Upon hearing this, I contacted the local office of Salt Creek to see if we might also be released from our contract so there would be no conflict of interest with me on the Board of Adjustment. I was told that I needed to talk to Bob Bergstrom, and I was given his number. I called Bob, and I requested the same from him, explaining, and he said that, he told me that no, we could not be released from our contract and that there shouldn't be an issue since I was not an elected official. I can only assume that if there was no thought of me having a conflict of interest at that time, that there really should be no thought of me having a conflict of interest now. So I was not going to recuse myself from these proceedings. Thank you.
Nancy?
Yes, thank you. I would also like to speak to the crowd. I would like to disclose before this meeting begins that it has been suggested to me that I should abstain from participating in this meeting because of a perceived conflict of interest, but that decision is ultimately mine to make. In 2022, 2 years ago, I shared my opinion with the Board of Supervisors and at a zoning commission public forum that the outdated wind energy conversion system ordinance from 1998 needs to be updated to the 21st century. It was and is my First Amendment right to speak publicly about this county's ordinances. I might add that that was 1 year prior to the Board of Supervisors voting unanimously on November 13th, 2023, to appoint me to fill the open seat on this board. The minutes from that November 13th meeting state, and I quote, "There were comments regarding the vacancy on the Board of Adjustment. It has been vacant since the end of June, and no replacement has been made. It was advertised and an applicant was interviewed, but no decision has been made yet. Trying to achieve gender balance and getting someone who may have different views than the members currently in place may be good to make sure all sides of an issue are looked at." Several of the public in attendance shared their support for the applicant, Nancy Yuska. The issue at hand tonight is a procedural issue dealing with the zoning administrator and his issuance of zoning certificates, not the overall opinion as to whether wind turbines in Tama County are good or bad. It is my personal belief that I do not have a conflict of interest with respect to the appeal under discussion tonight. I do have a personal interest in the welfare of Tama County, and that is not a disqualifying interest. Thank you.
Thank you. We'll take a roll call of the board members. Nancy Yuska,
Here,
Kurt Kelly,
Yeah, here.
Nikki Novak,
Yes, here.
Todd Sebesta,
Yes.
Mike Shedder. Here, so you all know who we are, so if you have any questions as time goes on. I need a motion to approve the agenda.
I'll make that motion to approve the agenda.
Need a second?
I'll second.
Thank you. All in favor?
Aye.
Motion carries. Everybody had a chance to read the minutes of the previous meeting?
Yes.
Any questions, comments? Okay. Tonight we're here, and Nancy even touched on it, to discuss whether or not Bob Volkun, acting as a zoning commissioner, acted within the ordinances of Tama County, issuing the permits for the wind turbines. That's the only issue we're talking about. We're not talking about for turbines, against turbines, cups, anything else. That's the only issue we're talking about tonight. So we may have some comments later on. Just make sure that you keep your comments strictly to that agenda item, because that is the only agenda item we have on the docket today, okay? I believe, Sean, you'll go first? Oh, wait a minute, excuse me. We've got some letters sent to us from people who were unable to be here tonight. Nancy will read those for you. Go ahead.
okay, there were 4 letters. First was from Charles and Lori Johnson, and it was sent to Bob Volkun on November 7th. To whom it may concern, I am writing to suggest that the Board of Adjustment have the wind turbine company go through the whole process again. The initial process started 13 years ago. A lot has changed and happened since then. Had I known what I know now, I would not have signed to have a wind turbine installed on my property. To me, this meeting is something that should have taken place years ago and did not. Now there are more considerations that need to be taken into consideration. New guidelines/policies need to be developed for Tama County regarding this type of construction. Respectfully yours, Lori Dixon Johnson. The next was November 11th, and it was sent to Bob. Dear members of Tama County Board of Adjustment, I am unable to attend tonight's meeting, and this is from Chris Behrens. I am unable to attend tonight's meeting, but as a citizen of Tama County, please accept my comments in written form. I am opposed to the issuing of permits for commercial scale industrial wind turbines in our county. There are many reasons for this, as I am sure you will hear at the meeting on Tuesday, November 12th. But as you proceed with your job as Board of Adjustment members, I simply ask that you reflect on the last several years' events. A referendum was put on the ballot in the fall of 2022 to expand the Board of Supervisors from 3 to 5. This took a petition of over 1,000 signatures. It subsequently easily passed. Then, recently, the voters of Tama County elected 5 board of supervisors with similar views on industrial wind turbines. Opposition. There is one clear reason all of this happened. The majority of the citizens of Tama County do not want wind turbines. This cannot be debated. It has been proven without a doubt by the democratic process, elections, and voting, the way it should be. I urge you to recognize this and perform your duties, understanding this is what the majority of people in Tama County want, no industrial turbines. Thank you for your time. Chris Behrens. Today we received from Tricia Jessena, Dear Tama County Zoning Administrator. This letter is in regards to the Tama County Board of Adjustment appeal hearing on the issuance of new zoning certificates for the building of 60 wind turbines and 1 substation in Tama County. My family is in favor of the appeal and strongly objects to the new building permits being issued for the wind turbines. Back in December of 2020, I had voiced my opposition at the Zoom meeting where the conditional use permits were approved. I had asked the Board of Adjustment for more time to postpone their vote since I felt the public had not been informed on the project. Now here we are, 4 years later, no turbines have been built and the building permits had expired. You would think this would be the ideal time to pause and take the time to listen to the many residents and landowners of Tama County that are opposed to wind turbines and have made their voices heard, but instead, much like in 2020, this is once again being approved and passed through. I feel the majority of Tama County residents and landowners are against wind turbines and see the need for the ordinances to be updated. Now is the time to listen to the people of Tama County to make things right. Sincerely, Tricia Jessena. And the last one is from Laverne Wagner. Tama County Zoning Commission. I am Laverne Wagner and just finished my 51st year farming in Spring Creek Township. I have signed up with Salt Creek Windmill personnel to have a windmill built on my property. My neighbors have had windmills for years now and enjoy the extra income and increasing their land value. This in turn raises more tax income for the county to help support the EMS teams, our schools, and to pay for the extra county supervisor wages that Tama County incurred. I live 3/4 of a mile from Highway 96 and hear more noise from the highway traffic than I hear from the windmill 3/4 of a mile away. I have been looking forward to the extra income to help during lean years that come with farming. Times have changed over the years and coal is not an option for power plants and natural gas seems to fluctuate price-wise for a source of electricity. Wind power is a natural resource to keep the lights on for our future down the road. Laverne Wagner. That's 4 letters.
Thank you. Okay, we'll hear from you first, Sean. As I said earlier, the only issue we're dealing with tonight is whether or not Bob Volkoon issued the permits to Salt Creek.
Right.
Okay, so
Understand.
let's all stay focused on that issue because that's the only item on the agenda. You have the floor.
All right, just to introduce myself, I'm Sean Shear from the Shear Law Office in Des Moines. Haven't been up here to talk to you before. I recently moved back to Iowa. I grew up in Des Moines, but spent the last 10 years in Texas doing oil and gas work, and familiar with what industrial energy companies can do. And if you look at southern Iowa, at all the unreclamated coal mines that are down there, and then you look at what's going on in Jasper County, they've got 1,000 blades, turbine blades laying on the ground. Nobody wants to clean them up. Mid-American says it's not their problem. And in this situation, it doesn't appear that there's been sufficient vetting of Salt Creek Wind's capabilities to handle the decommissioning, and that is an important part of issuing these zoning certificates. Is it does Salt Creek Wind have the financing and the funding to be able to take care of their obligations underneath the road use and decommissioning arrangements? And I'm going to have some questions for Mr. Volkoon about what he has done in terms of received a copy of the appeal document that I filed, is that correct? And did you get, there were 3 or 4 exhibits to that? Okay. Which were, 2 prior appeals, that didn't get heard. One filed by Heather Neville back in, 2021 area. Then one that was filed, upon a grant of an extension of the prior zoning certificates. It was 26 months, and then they were gonna be given, I forget, another 9 months. But when Salt Creek Wind gave up the old certificates, that became moot. There was no need to, and I believe you voted that it was moot, and that was gone. And then there's also a copy of the case that was filed against Salt Creek Wind in the county, that's since been dismissed again because it became moot with the forfeiture of the prior zoning certificates. But the allegations in there we haven't had the opportunity to do discovery on those, as to what background work has been done on Salt Creek Wind and what their plan is for this project. Is it being sold to somebody? Are they just putting together the papers that don't have financial capability to build out this project with that? And if they don't, that's not necessarily a problem in and of itself, but I think before you issue zoning certificates, you should first find out who it is that's going to be responsible, so you don't end up like Jasper County with thousands of blades laying on the ground and nobody able to finance and clean them up. And the decommissioning agreement was a condition to the granting of the CUP, and it wasn't entered until after the CUP had been approved. And I know you don't want me to talk about the CUP, but I think that's an important problem, because if the CUP was adopted and inconsistent with the law, it still remains an invalid act.
I'm gonna object, and that'll be a standing objection with respect to anything with the validity of the CUP. The only way to appeal that would have been a writ of certiorari to the district court some years ago. That did not occur. That has not occurred. The lawsuits that were pending have been dismissed, and this board must presume that to be a valid conditional use permit because it has not been overturned by a court of law.
Sean?
In response, they'd say, I'd cite several cases. The city of Lamoni versus Livingston at 392 Northwest 2E 506 in 1986. That says that where a permit is regularly issued in accordance with the relevant zoning ordinance, it may not be revoked if the builder has relied on it. However, when there's been no compliance with or authorization in accordance with the ordinance, the deficiency is deemed jurisdictional. And it also says if a permit is issued without legal authority, it's always illegal. If the CUP was adopted inconsistent with the law, then it's never going to be legal. And I understand he says there's a 30-day certiorari. I disagree with that. We can table that for now, but I want to preserve that issue for appeal coming out of here, because I believe that we don't need to do that in 30 days if the CUP itself was inconsistent with the zoning ordinance at the time it was adopted. It never becomes, the passage of time does not make an illegal act legal. And that'll be my response, and we will deal with that, maybe in post-hearing briefing, or if there needs to be an appeal, we can deal with that, but I just want to preserve that, okay? I don't know if you have all of the zoning certificates that were issued by Mr. Bocone.
That was in the packet that you, correct? Okay. We all got copies of them.
Okay.
Yes.
Yeah, and there are 2 things that I wanted to point out on these. All of them, nearly all of them I've noted, all say that the present use of property is cropland. And I have a code 335 No, this is a state law.
Oh, state law.
Yeah, the state law. And it says no ordinance adopted under this chapter, so that would be the Tama County.
I'm
Zoning.
going to object to this as well. This board is not in a position to rule on the validity of the county zoning ordinance. Like the CUPs, it must presume the zoning ordinance is adopted lawfully and to administer it accordingly.
I don't think I'm challenging the zoning ordinance. What I'm challenging is that the zoning ordinance is prohibited by state law, 335.2, to apply to land that is primarily adapted by reason of nature and area for use for agricultural purposes while so used. You cannot, the cup cannot apply to row crop
I have a
land.
question before. So, what you're saying in essence is that any cropland cannot be converted to anything else?
It needs to be taken out while so used, so it needs to be taken out of production before the cup applies. That is my position, that as long as it is being used for row cropping, you cannot, under the cup or the zoning ordinance, grant a building permit for a non-agricultural use.
Can you reserve this as well, because my objection stands.
Right, and that's the point is, all of the zoning certificates say that the current use is cropland. 335.2 says the zoning ordinance can't regulate cropland while so used, and therefore the cup only applied to non-cropland inside the agricultural district. So if somebody wants to take a year off and not grow where the turbine's gonna be, then it's no longer being used.
Again, I'm gonna have to object. This has nothing to do with whether Bob Vokoun acted in accordance with the zoning ordinance when he issued these 61 permits.
And I'm not understanding that objection, because the question is, does the zoning ordinance apply properly? And if he granted certificates for cropland before it's been taken out, and while so used as cropland, the zoning ordinance cannot by statute apply.
And that would be for a court of law to determine. The Board of Adjustment has previously granted conditional use permits for these specific areas. This is not for the board now to consider whether that was appropriate or not. The time to make that argument would have been 3 years ago now, I think.
I guess I'm not understanding that. These were just issued less than a month ago.
You're questioning the validity of the zoning that's been enacted, you're questioning the validity of the CUPs that's been enacted, and you're trying to rewind the clock to get at things that should have been appealed previously into the district court.
It's fundamentally a jurisdictional question. Does this board and does Mr. Vokoun have legal authority to issue the certificates that he did?
They do not have the legal authority to overturn conditional use permits or to overturn the Tama County zoning ordinance. They must accept it as written.
That is correct, and also they have to accept it under the limitations imposed by the Iowa General Assembly, which is that the zoning ordinance in the CUP cannot be applied to land primarily adapted for agricultural purposes while it's so used.
They do not have the authority to make that decision.
Explain it to me why they don't have the
The
authority
only
to decide their own
jurisdiction, the only jurisdiction of the Board of Adjustment is to make determinations on enumerated variances and exceptions, to hear appeals of Bob's decision, which is why we're supposed to be here tonight. And that's it.
Right, and I'm saying Bob's decision is illegal.
You're asking Bob to substitute his judgment for a court of law, the Board of Adjustment, or the Board of Supervisors.
So the county's position is that the zoning administrator has no obligation to understand the law that he is implementing?
His obligation is to administer the zoning ordinance, including the conditional use permits that were adopted by this board in 2021, I believe.
Correct. And he's also not supposed to issue zoning certificates on land that is currently being used is for agricultural purposes. That's number one. That's the one thing I noticed on all these applications. The other thing I noticed is that all of them talk about a GE, the type of turbine as being a GE 2.82-127 at 89 meters of hub height. But when you look at the cup, that model, they listed 4 possible models on page 7 of the large cup application. And it's a GE 3.03, 140, a GE 3.03, 140 with a little bit more height, and then 2 Vesta 150s that have differing heights. The GE 2.82-127 it was never disclosed, and the CUP does not give authorization for them to issue a building permit for a model of turbine that's not in the CUP. The other thing is, when you go back and look at the CUP, all the studies included in there are quite dated. The documents were in 2020, but the data was collected for a year prior. The avian studies.
I think we're getting a little off topic.
Well,
I sorry to interrupt you, but you've been on cups now for the last 5 minutes.
Well, the question is,
I would concede that this is an appropriate point.
It's an appropriate point?
I don't believe you're arguing as to the adoption or the propriety of adopting the cups, correct?
No.
Okay.
No, I
misunderstood you.
No, this goes to the question of whether Mr. McCoon's decision was unreasonable, arbitrary, or capricious. Should he be issuing building permits based upon 5- and 6-year-old data that was required by the zoning ordinance to be submitted at the time the CUP was filed? And the CUP, they've had those building permits, the original ones, for 28 months, and didn't do anything besides dig those 4 holes, and which raised the question of can you be relying upon 2019 data in late 2024, early 2025, and is that a reasonable decision by Mr. Vokoun? And one of the standards for an illegal act is if it's unreasonable, arbitrary, or capricious, which means it needs to be well thought out and not a knee-jerk reaction. And to me, relying on 5-year-old studies, the eagle's nests have moved. The bat study they did was for endangered northern Indiana bat was 3 pages and never vetted. The phase 1 environmental study that was attached to the CUP has draft written across it, and even if, as in the brief, even if that phase 1 environmental study was valid and it wasn't simply a draft, it's only good for 6 months, and after that it has to be redone. It can't be relied on, and that's in the brief on the general standards governing environmental consultants that prepare those types of reports. So without updated information, our argument is that the decision to issue these zoning certificates is unreasonable, it's arbitrary, it's capricious, it's not studied, and it's not reasoned to be issuing those permits on the basis of 5-year-old information. I would like to ask Mr. LaCoon a few questions, if I could, about his process of issuing these. Mr. LaCoon?
Would you like me to come up front?
Oh, no. I didn't know.
If you could, since we're recording.
I'll try to keep this short. When did you receive the applications for these 60 permits?
I'd have to refer back to the notes, what it's dated on. I don't recall the exact date, I'm sorry.
Yeah, well, they're signed like 9/16. Does that sound? Did you get them?
They were signed on the 16th.
Yeah.
I forget without referring back to notes on what exact day they came in.
Bob a sample
Yeah.
of the applications for record.
Last back on. Okay, these are dated September 6th of 2024. This is the date of application.
Okay, so that's the.
I'm sorry, I didn't recall the exact date.
No, that's fine. So between September 6th and this one I'm looking at was signed on September 16th by you and was approved. What process did you go through to evaluate the applications to make the decision to approve them?
Going through each one and individually, specifically the maps, checking distances. I did have a question on some distances, and I would refer back to council on that. Going over things to make sure that the CUPs were still valid, like I say, talking with council, and making sure that everything was in line the way it was supposed to be, that I wasn't missing something or somebody else wasn't missing something.
Are all of the locations, for being longitude, latitude, locations, are they all identical to the locations that were in the 2020, building permits?
I believe so.
Okay. Now the substation is not in the same, going to be in the same location that was in the original plan, is it?
I don't recall where the original one was. I just did look at the current one.
Did you notice this different, that it was a GE 2.82127 model that they were proposing?
On the models on here, no.
So you didn't compare the model listed here to the models that were in the cup?
To the old ones?
Right, or the models that were listed as the potential models in the cup?
No, I referred those questions to council.
So you did ask council about the different model number?
About everything, going through everything, if there was anything, any specifics or anything that needed attention that I may have missed.
But I want to get your statement correct. You're not sure whether the substation that the building permit has been given for is at the same location that the substation was planned for in 2020?
No, I don't recall what the original station was.
Did Salt Creek Wind explain to you why they gave up their old zoning certificates and then turned around and applied for new ones?
Well, the information that I have is that they were in whatever legal situation, discussions, and at that time they chose to surrender, the word that was used, their current zoning certificates.
Are you familiar with the legal issues that Salt Creek Wind was facing?
A little bit, there's all kinds of stuff that's been going around, and, you hear all kinds of stuff.
Have you confirmed whether Salt Creek Wind has the contractual right to build this project?
I guess I'm not understanding what you mean by their contractual right there.
One of the cases, and that's discussed in the exhibits, against Salt Creek Wind by Southern Natural Resources, said that Mr. Bergstrom, both Bergstroms had taken data that was created by the prior Salt Creek Wind, and then used that data as part of their application for the CUP. And the argument that Southern Natural Resources was saying was, yeah, the non-compete, Bergstrom can't build turbine projects in Iowa. Were you aware of those allegations?
I'm sorry, I'm not familiar with any of those cases.
Have you done any work on the financial capabilities of Salt Creek Wind to perform its obligations under the road use and decommissioning plans?
As far as me personally checking into that, no, I have not. I refer that type of situations to council.
So, you believe council has investigated the financial wherewithal of Salt Creek Wind?
I believe so.
Can you describe for me how the decommissioning plan works, and your understanding of it?
In this particular case in detail, no.
Do you know if that plan requires financial security in the form of either cash deposits, bonds?
I know it requires securities, but to the specifics in this case, I do not know.
These maps that were presented to you as part of the applications, were these the same maps that were used by Salt Creek Wind in their 2020 permits?
Well, I don't know if they were the exact same ones or what difference there was or anything. When I was looking at them, they appeared to be very similar. If there was any little difference or whatever, I didn't pick that out. We went by the new applications.
Do you know how they prepared these maps? Is this just computer-based aerial photos that they were using?
How exactly they did it, I do not know.
Okay, but do you know if there was an actual, did surveyors go out to these properties?
Again, I can't answer as to what surveyors or what went out to that.
But did you get official survey reports from any physical survey of these areas?
Well, I received the maps that showed the
Just these
distances.
maps? Because that is one issue that is raised in the brief, is that in order to issue a building certificate, a zoning certificate, it needs to be accompanied by an actual survey showing the boundaries of the property. And you don't have an actual survey other than these maps that were generated by.
I'm not aware, there may be something in the file that wasn't given to me or something, but I'm not aware of the actual surveyor company or whatever, if it's listed on here.
Does Salt Creek Wind given you any estimate on when they would plan on beginning construction?
What I was advised was they would commence construction as soon as possible.
And do you know who's going to be doing the construction work?
It's listed on here as far as the contractor, Simon Miller Bechtel.
have you gained any information from Salt Creek Wind on what the industry calls the off-taker? Who is going to, when this is built, do you know who is going to operate, the project?
As far as after the developers are done with it, when they sell it,
Mm-hmm.
I don't recall who's looking at purchasing it or what's all going on there, if they're finalizing anything or where that stands.
So after it's sold, will that buyer be subject to the road use and decommissioning agreement?
As far as the buyer,
Mm-hmm.
whatever arrangements that are made, I can't answer as to specifics. That would be something that council would have better information on.
I'm not gonna go through the whole history of Salt Creek Wind, other than to point out that the entity that was Salt Creek Wind in 2009 is not the same entity that arrived in 2019. Were you aware of that?
No,
Okay. There have been materials, and I received a letter late last night from counsel for Salt Creek Wind, and I received a memo from Mr. Levinger late last night. And in the letter from Salt Creek Wind, it indicates that they claim to have spent $13 million on this project to date. Do you know on what basis that the Salt Creek Wind?
I think there's a phone that they're listening to.
that would be Mr. Kelly on that.
Oh, okay.
Could we check in on him real quick?
Yeah.
Mr. Kelly, you still there?
Yes, I'm here.
All right, thanks.
So you don't know what the basis of that, where that.
As far as how they're spending their money, no, I don't have any
Okay.
idea.
Have you confirmed that Salt Creek Wind, a Delaware company, has spent $13 million as opposed to the Salt Creek Wind from 2009, the Salt Creek and Southern Natural Resources, who had bought the data from Salt Creek Wind, the original Salt Creek Wind?
I personally have no knowledge of any of their investments and their money. I have no reason to.
All right, I think that's enough for questions for you. Is there a Mark Early here?
Who?
Mark Early? Yeah, I just have a couple questions for him. Yeah. Is he here?
No. Oh, he is?
Yes.
Oh, I'm sorry.
Yeah, I'll give this to you. It's a document that was introduced as an exhibit in the Worth County litigation, and it's entitled Tama County Landowners Association LLC, and I'll let you look at it here. It lists you as a member from 2009, and it said you were going to go through a process of soliciting, reviewing, and negotiating one or more suitable land use agreements and putting out a request for proposal to submit to 4 wind development firms that you considered suitable partners for this endeavor. Do you remember this?
Does this have to do with the agenda?
Well, my question is whether or not a similar RFP was done in 2019.
Failing to see the relevancy.
Well, the big question is, the question is, I don't understand why this group is doing an RFP that involves placing turbines on land that's not theirs.
Objection. Again, what does this have to do with granting these turbines, turbine permits?
Is that related at all to this?
Yeah, I think that if the entire process has been included fraud, false representations, that were in the cup, and the cup contains bad information, contains old information, and in order for a reasonable decision to be made by Mr. Locone, these types of outside influence, non-elected influences in the process, as well as the lack of current information goes to the standard of unreasonable, arbitrary, and capricious, which would make his act illegal.
Objection, that's not even the legal standard here. I'll address it in my
Okay.
direct.
Did you confirm that Salt Creek has the legal ownership positions for all of the parcels that are listed in the application?
As far as each one, yes, they're confirmed, and that's going through legal counsel and everything, make sure that everything is proper and correct in that respect.
So you don't collect easement agreements or option agreements
No, that doesn't
from
come
Salt
in.
Creek Wind to confirm whether or not they have an ownership interest in the land on which they're proposing to build?
Yeah, that doesn't come to my office in the application.
Do you know if their FAA authorization is current?
That is taken up with the FAA, and I did not deal with that.
So you didn't collect any documentation from Salt Creek Wind to confirm the FAA authorization they had is still effective?
From their previous, again, that all gets referred to council to make sure that that is all valid.
So if it had expired in May of 2024 and they don't have FAA approval, would you have still issued these zoning certificates?
If I'm advised by council that there's a problem, then we address that.
And I'll object to that. It's actually speculative.
Were letters sent to everyone with land adjacent to the proposed turbines to invite them to this meeting tonight?
Yes, the list that we were provided, and that got sent out, I believe it was 1,200 feet.
Was it the same list that was used in 2020?
I believe there were some differences because of possibly some changes in ownership and so on, so we were provided a current list.
And who provided you that list?
That would have been the council from Salt Creek.
Did they tell you they were gonna be using a different model than what was in the code?
As far as, I was just given the model that's on the permits, on the zoning certificate applications.
So as part of your process of going through these permit applications, did you evaluate whether they were consistent with what was disclosed in the code?
That again was referred to council, if there was any issues with the cups and issuing the zoning certificate.
In the letter I received from Brown Winnick, the counsel for says, she writes that, has been documented in prior communications with the county, construction timelines for a project of this nature run significantly longer than what the ordinance allows. Have you received timelines from Salt Creek Wind on the project?
I believe I received that letter.
Yeah, just this letter, but it's saying it's been documented in prior communications. Have you ever seen a construction timeline from Salt Creek Wind?
As far as setting down on when they are doing driveways and when they're doing pads or so on, there's nothing been listed as far as.
Objection, I fail to see the relevance with respect to when, the question of whether these permits were granted appropriately.
I think it goes to, once again, his diligence, whether it was a reasonable or arbitrary decision.
Which, and again, is not the legal standard here.
Why do you think that's not the standard?
You're citing the standard for legal review on a writ of certiorari of a government body's lower decision. That would apply to this board's actions. For example, if this matter were, if you were to go to the district court tomorrow and file an appeal of this action, ask for a writ of certiorari, that's the standard that would apply to this body here. They're required to issue written findings of fact and to demonstrate that they've acted reasonably and not arbitrary or capriciously. With respect to the zoning administrator, whose actions they're reviewing, he's merely required to act consistently with the zoning ordinance. And that may, yes, that may involve acting prudently, but I don't want to confuse the legal standard.
Well, we will agree to disagree on that, because I believe that standard also applies to individuals employed by the county, making decisions as to whether the facts in an application are consistent with the disclosures in the conditional use permit, and if there was no diligence done at all, that approval of that would be a violation of this board's duty to prevent unreasonable, arbitrary, or capricious actions by the county. But we'll save that for our writing later.
Simply trying to make certain that there's no inference that written findings of facts would be required primarily by pointing that out.
Brown Winnick also speaks about vested rights, and I want to just briefly address that. And I believe I quoted some cases for you earlier, and they're in the brief as well. And this is where I have a problem with not addressing the cup. This is the city of Luana versus Livingston, 392 Northwest 2nd, 506 from U.S. Iowa Supreme Court, 1986. And it says, where there's been no compliance with or authorization in the ordinance, we have held that because the permit was granted wholly without legal authority, there was no power in the zoning officer or board of adjustment to grant it in the first place.
Objection again.
This goes to, if this was cropland and the zoning ordinance doesn't apply to cropland, the act of trying to place a conditional use on cropland, it violates 335.2 of the Iowa statutes, and it's an illegal act.
If there were a judicial determination, it would have been an illegal act.
Isn't this board supposed to make the determination as to whether the issuance of these zoning certificates were consistent with the law and the CUP? If the answer to that is yes, and I believe that's what they're here for, the question is, if a CUP cannot apply to cropland while being used as cropland, then you can't issue building permits to build non-agricultural structures on what is now active cropland.
That would have been a good point to make in 2021. When the Board of Adjustment considered this exact issue with these exact sites, which I presume would have been cropland at that time.
Right, it's always been cropland.
You're asking Mr. Vokoun to be, basically be a judge and a jury here.
Yes. Yes, I am. I think that's his job, is to make sure that his actions are legal.
Based on the Iowa code and the zoning ordinance, it's the district's court's job, and it hasn't been given that opportunity because an appeal has not been made.
So the findings of fact are not going to include a statement that Mr. Vokoun acted with proper legal authority. Is that what you're saying?
Would be that he acted consistently with the county zoning and he administrated the county zoning appropriately. Not that he investigated the origins of the county zoning back to their inception.
Do you agree that Iowa Code 335.2 applies to the county zoning ordinance?
Like, generally,
Yeah.
does the county and zoning have to comply with that?
Yeah.
Yes, it does, but the determination of whether it hasn't is not Bob Vokoun's job, it's the district court's. You're free to bring that challenge to the district court, or you would have been free had it been made within the appropriate period of time.
But, okay, well, we're challenging, we're only talking about these new permits, correct?
Correct.
Right. And the challenge that we're here was filed within 30 days of those being issued, correct?
Correct, but there is a conditional use permit that was granted for these exact sites down to the GPS coordinates, that this is a approved conditional use of that very land, that they can be used for a wind turbine. Now, they've gotten that approval, they're simply coming forward for a certificate that says they're building pursuant to that in the appropriate locations with the appropriate setbacks.
On what is now existing cropland.
Again, that would have been a good argument in a discussion to have, not a good as in meritorious, it would have been a good argument to raise at that point.
But there, this is my point, is that there are portions of the agricultural district that are not active cropland. And the CUP would apply to those non-cropland areas of the agricultural district. But it can't apply to active cropland.
The Board of Adjustment has approved a CUP for these exact 60 locations with GPS coordinates. It's already been approved. It's not Bob's decision to make whether the Board of Adjustment did its job 3 years ago. It's his job to administer the decision they made 3 years ago, as long as it remains valid.
Right, and their decision was that GE 3.03 140s were gonna be built, or Vesta 150s were gonna be built, and we're gonna be building GE 2.
Do you know if those models are still made, if they're comparable?
You're saying that we have to hold the process in 2020 to a high standard that can't be questioned. And if they have an approval for these exact locations, they had approval for these exact locations to use these models. And
Proceed with your argument.
and it changes, because the heights are different, it changes whether or not the noise study that was submitted is still applicable. It changes whether or not how the avian studies, the Raptor studies, are, you know, if this one's at 89 meters, well, now I'm doing my math, you know, that's 300 feet, and these were 600, some of them. So these, you know, the ones that they're proposing are smaller in terms of height, which will necessarily mean the ground clearance is gonna be different. Whether or not they're closer to the ground, they're gonna be closer to a residence, and whether the sound study is still any good, whether the maybe flicker is going to change based upon the height of the model that's chosen, and the information contained in the conditional use permit submission in 2020 was assuming a different model in the studies that they submitted. And I don't think, based on that information, it is a reasonable decision to issue building certificates that are contrary to what is in the cut. And I'll leave it at that, and I do get a rebuttal, don't I, here at the end?
Yeah.
Okay.
Are you,
Yeah, I'm done.
okay. Bob, do you have any comments while you're sitting there?
No, I didn't,
Okay,
just answering questions.
okay. Steve?
Alright, just to, so, at the time you received these applications for zoning certificates on September 6, 2024, there was an existing conditional use permit in effect, correct?
Correct,
And that was adopted by the Board of Adjustment in, I think I've been saying 2021, I think it's 2020, in October of 2020.
yeah, I believe it was 2020, I cannot say exactly without looking at the papers.
And to your knowledge, has the Iowa District Court ruled on the validity of the conditional use permits?
I am
Have
not
they held
aware,
them invalid?
I'm not aware of any ruling,
Have the conditional use permits expired pursuant to the terms of the zoning ordinance?
no,
So as far as you're concerned in your role as zoning administrator, those conditional use permits are valid?
correct.
And I previously had you look at this. Could you take a peek at that? Can you identify that document?
This document appears to be a copy of the Tama County Zoning application for zoning certificate.
Okay, and
It refers to turbine number 1,
okay, so that's one of the 60.
correct?
And is that representative of the other 59?
Yes, it certainly
Similar,
appears to be.
similar.
Similar, correct.
And does that provide GPS coordinates for the turbine?
Yes, it does.
And does it provide a legal description for the property?
Yes,
Does it provide the height of the turbine?
yes, it does.
Okay. In looking at page 3 of that exhibit, does it depict the location of the proposed turbine?
Yes, it does on the color map.
Does it indicate the turbine lengths, distance to right of way, distance to edge of the parcel and whatnot?
Yes, it has all those measurements listed there.
Okay. Does it include dimensions with respect to certain setbacks?
Yes, it's got everything to property lines here and residences, and buildings, it's all noted here.
Is it drawn to scale?
I believe so. There's also a scale bar on the drawing as well.
All right. And does it provide measurements to 1/100 of an inch?
Yes, it does.
Okay. Does it indicate it was prepared by a professional engineering, architectural, and surveying firm?
Yeah, there's some small writing here, I'm sorry, it's kind of microscopic.
Yes, that should give me a bigger copy.
Things are listed on here.
But it appears to be a professionally prepared,
Professionally prepared
and it has
document for this
the
purpose.
name of the maker on it.
Yes.
Alright, I'm also gonna ask you gonna provide a copy of the section 2001 of the zoning ordinance so that you can refer to that. Alright, could you, section 2001, what's the title of that provision?
At the top, it's Article 23, zoning certificates required.
No, 2001.
Oh, I'm sorry, Section 2001, I'm sorry. Procedures for certificates.
Okay. Did you follow that procedure in granting these zoning certificates?
Yes,
Did Saltland utilize the county's prescribed application form?
yes, they did.
Did they include legal descriptions?
Yes,
Did they include names of property owners?
yes, they did.
Did they include a description of the proposed use?
Yes,
Did they provide the cost of construction?
yes, they did, the estimated cost.
And is there a dimension drawing there showing the location of structures and parcels?
Yes, it refers back to the map,
Right. And that scale, correct, as well?
correct.
And so, in your opinion, as the zoning administrator, did each application that was submitted comply with the requirements of section 2001?
Yes, it did.
And did you also review these applications relative to the existing conditional use permit?
Yes, and also conferred with council on, in case I was missing anything, is everything is valid and good and matching up.
Did that include ensuring that each application corresponded to a site specified in the conditional use permit?
Yes,
That the setbacks specified in the conditional use permit were met?
yes,
That the heights of the proposed turbines, did you confer those were consistent?
yes,
And you generally ensured the applications were consistent with the conditional use permit?
yes.
And at any time during your review of these applications, did you find any information to be missing or need to follow up with the applicant for anything?
Yes, I did.
And did they provide that?
Yes, they did.
And ultimately, you determined the zoning certificate should be granted, correct?
Yes,
And how long does the zoning ordinance give you to review these applications?
the zoning ordinance lists 7 days.
How long did you take?
This one took 10 days.
And the applicant was okay with you taking that additional time since you had to track down some additional information?
Yes, I had to advise that this was going to take a little more time because of the other information I was requesting and then being able to go over it and confirm.
Now, I asked Bob to forward you all a brief in the hopes we wouldn't have to sit here and wait for you to read it. Did you guys have a chance to see that?
Yes.
Okay. Again, I'd just like to touch on the fact, I can appreciate folks caring about their community. I can appreciate that people have differences of opinions with respect to whether alternative energy or wind turbines in particular are a helpful or hurtful thing. But the sole issue here is not whether these are good or bad. In a time for public opinion, would have been back in 2020. Doesn't mean that public opinion's invalid or that people's thoughts and opinions don't matter. They just don't matter to this particular proceeding. And it would be unfair to this proceeding to allow those to enter in. And further, it's inviting the Board of Adjustment to make decisions it has no right to make when you're asked to review the validity of that CUP. The standard that the zoning administrator is required to look at when permits come in are listed in 2001 of the zoning ordinance. It's titled Procedures for Certificates and includes what documents have to be provided. As Bob testified, those documents were provided. I think it's important to remember that a zoning certificate is not the end of the story. It doesn't supersede the zoning ordinance. It doesn't supersede the conditional use permits. It merely permits the applicant to commence constructing what was approved previously. And ultimately, you're looking to confirm that what's being built is what was approved and that the situated appropriately on the property. The wind turbines and the substation still have to comply with the zoning ordinance and the conditional use permits as constructed. Has to comply with all state, federal laws and regulations. So to the extent the FAA requires an updated this or that, that's going to be necessary. Again, it's not the end of the story when a zoning certificate's issued. Obviously, no zoning administrator is going to be a judge. It's not the training, that's not what's required for the job. What's required is to be able to administer the laws and rules that have been put in place by the county and the board. With respect to the survey, there's no requirements in the zoning ordinance like there may be in certain sections of the Iowa Code that the survey be prepared by a particular profession, that it be certified within a particular period of time. Merely refers to a survey of the land. Again, not a defined term. Black's Law defines it as a measurement of a tract of land in its boundaries and contents, or a map indicating the result of such measurements. I think it would be reasonable to conclude that a scaled and dimensioned drawing down to 1/100 of a foot, prepared by a professional firm, in fact relied on a survey. It would be, if I'm a professional engineer, I'm not putting my firm's name on that document if I haven't done my due diligence. And I think that's reasonable to infer from here with the specificity and whatnot that it was based on a survey. As to the comments made about the conditional use permit submissions back in 2021, those aren't required submissions for a required submissions for a zoning permit are specified in section 2001. Those studies and whatnot were available to the Board of Adjustment at the time it was granted, and it felt that they were sufficient to rely on to grant these things. A lot of attention was given to Phase 1 ESA. I just note that that's not even a required submission under the zoning ordinance for someone applying for a conditional use. So to the extent that may have been a draft or may not be up to date would be immaterial under the zoning ordinance. And again, just asking this board to focus on the facts at hand. Both Mr. Scheer and myself have made arguments with respect to whether Bob acted appropriately when he enacted these. There's been some additional testimony I would say irrelevant, that is irrelevant, and I would ask you to focus on the relevant arguments that were made as you look forward, and that you decline any invitation to exceed your jurisdiction. Again, the ultimate question here is whether Bob erred in applying the zoning code when he granted those 61 certificates on September 16th. That would be it for now.
Okay.
I just have a couple of follow-up questions about what his answers.
Okay.
Okay. You were asked whether the cup had expired. Remember your answer, and you said no. Does the cup expire?
I'm not exactly sure on how that actually operates. I checked with council to make sure that the cups were still valid.
Okay. But you don't know if there's a standard as to the cup is only good for 5 years, 10 years, 15 years?
No, I do not. I do not know how long that goes. I just checked to see if the cups were, make sure that the cups were still valid.
Nate, you ever asked whether you confirmed whether the height was consistent with the cup? How is the 89-meter height consistent with the cup models that are listed?
As far as the models, I referred those questions to council to make sure that everything was correct and was appropriate for the zoning certificate.
And you said you asked Sucker Wind for additional information.
That's correct.
What did you ask for?
I asked them for additional distances to buildings and residences.
So they didn't have all the measurements on these maps?
Well, what they had was the nearest residence that was occupied. And I asked them to include all of them that were on the map.
Okay.
I wanted to see measurements to all of them.
Now, the issue of the actual survey language came up during your discussion. When somebody submits for a zoning certificate to construct a new residence, do they turn in blueprints to you?
Yes,
Have you had any blueprints for these turbines submitted to you?
as far as the blueprint for the actual turbine, no.
And do you have, when somebody requests a zoning certificate for a residence, do you require a surveyor to go out and survey the plot where this is going to be?
The only time a surveyor needs to go out to that is if they're purchasing more land in order to build. If that is the case, then they do so. Everything is recorded at the courthouse. And when everything is recorded, then I am informed and given a map of the property lines. The building permit then shows where the structure will be going and shows measurements and so on. And then we make the determination as to how we are granting the zoning certificate.
So why were the processes you used for these turbines less onerous than what you use for the construction of a residence?
Objection, is that what you're saying?
I'm sorry, I'm getting confused here, what you're.
I object, council's putting I feel council's putting words in.
You get blueprints for a residence and you get an exact location showing where the residence is going to be on the plot of land before you issue a zoning certificate for that residence to be built. Is that
See,
what
we
you're saying?
get the blueprints, and that also gets forwarded to the Tama County Assessor's Office. So they know, and as well as the county sanitarian will have questions as to how big the residence is, how many bedrooms, and so on. So that all applies to different departments.
But there are no things, nothing unique to wind turbines that would require that detail?
Well, the wind turbines, we are told what the models, they'll be listing those on there. And we know that that's what's going there. We may not have a specific measurement as far as the diameter of their structure.
And the only thing you have are the dot in the middle of each one of these maps.
They apply, when they apply for CUPs and so on, there are plans that go in there, so everybody knows what they're building. The dot on these maps indicate where that turbine is going.
Now, is there
And then
some,
that is, those measurements, I would assume would be from the center of that dot.
but is there some variance rate in the cup that would allow them to move this 10 yards to the north if need be, if they ran into some problem underground drilling or whatever, excavating? Can they move it from this location?
As far as if there's a variance in the cup, I don't have the answer for that. I can't.
And the maps are all by, the company's name is Westwood. Do you know anything about Westwood? It's kind of.
Not personally, no.
I guess I'm back in the same place that I was. This is cropland. The cup doesn't apply to it. The models are different than what was included in the cup. The residential process appears more onerous than this process, which I think indicates a lack of diligence. And the height is inconsistent, and so in my mind, Mr. Vilcone did not do complete diligence on these matters. He did check to make sure that they were all consistent with the cup, and he didn't confirm. One other question for you. He skipped this. It said when the types of information says you're supposed to describe the use to be expanded, the proposed cost, the construction or structural alterations of the building or structure, and you covered all of that in the questioning. But then it says, and any other information the administrative officer deems essential for the enforcement of this ordinance. Other than asking them to add the measurements to these other houses that you mentioned, did you ask for any other information from them?
That was the information that I asked for, and then I went to council and went over things again to make sure that I wasn't missing anything. And if there was any reason at all legally that there would be to deny this permit, as they were meeting all the requirements.
For non-turbine related zoning certificates, what types of information do you ask for that you might deem essential?
Actually, for the houses and stuff, we get measurements like this to the property lines, how tall they are, and so on. We get a lot of that information as well.
Is there anything else you deem essential for the enforcement of the ordinance in a non-turbine circumstance?
I get all of the information on the building, how big it is, if it's going to be, the setbacks are proper, everything just like these.
I think that's it. I'm remaining with my position that the CUP doesn't apply to active cropland, can't issue zoning certificates for active cropland. The disclosed models in the CUP are not models that are included on the zoning certificates, and therefore the issuance is inconsistent with the CUP, and I think those two things make it an illegal act outside of Mr. Vilcoon's authority, and we're gonna disagree, but I think Mr. Vilcoon is also subject to the reasonable, arbitrary, and capricious standard, and I don't think that the decision to issue these certificates for the reasons that I just articulated were reasonable, and saying the height is consistent, and it's not consistent whatsoever with what's in the CUP, just raises more evidence to me that these 60 applications turned around in 10 days, which is quick, and I think that also may indicate why the process wasn't complete and wasn't done with full diligence, and therefore the certificate should be revoked by the board.
And if I might now. Bob, didn't you testify that the code provides you 7 days
Yes.
to review these and to provide to grant them or deny them?
That's correct.
And you previously testified you took 10 days.
That's correct.
Would you categorize that as being too quick?
No, not at all, certainly not.
Okay. Furthermore, does section 2001, I'm not sure if you still have your copy there, of the zoning ordinance, does that require any blueprints of structures?
I do not believe it does here. Each application shall be accompanied by a dimension drawing of the lot showing of the location of the buildings, dimensions of the lot, and other information of importance.
But not blueprints or detailed plans of a structure.
Correct.
The location of the structure. Were you satisfied that the location of the structure and dimensions of the lots and other items of that nature were satisfactorily illustrated on the maps provided?
Yes, I certainly do.
And I think you were testifying previously to the analogy between residential and what's required for a residential building permit and what's for this. Are the nature of the drawings and whatnot substantially different in terms of the map you've been provided here?
Yes, I mean, sometimes people will submit plans with, they may have a map such as this of their property that you can get offline from the assessor's office.
And might they just have a more simple lot that shows setbacks? that's less professionally
Yes.
prepared.
Some are hand-drawn, you know,
And does
Some
the
choose-
application actually have a space where you could hand draw something on the application?
yes, it certainly does. So, in this case, they noted, see the attached, which a number of applications will, and then some just draw it on that.
Okay, and I just wanna make sure that the record's very clear. Did we have specific discussions on a substation location? Or turbine models?
No,
Or
no, we did not.
Rather, did you look over these and make a determination on your own that they complied, and then inquired whether it appeared you were missing anything?
Yes,
Okay.
that's what I did. I went through everything and then,
So you weren't abdicating your review to legal counsel, who would be myself. You reviewed these documents yourself.
yes, I did.
Okay. And in fact, you made your determination yourself, also, did you not?
Yes, yes, I did.
And then you inquired whether there was anything obvious missing.
That's correct. When I had gone through them, I had made the call to confirm that I wanted to make sure that I wasn't missing anything, if anybody saw anything that I may have missed, and any reason why these permits should not be granted based on our ordinance.
All right.
Any other comments, Bob?
I have none. Do you have any questions for me?
Any questions for anybody? If there's comments from the public, you're welcome to make them. I just ask, as I said earlier in the game, is we're strictly talking about whether or not Bob Volkun issued the permits according to code. We're not talking about for wind turbines or against wind turbines or cups or anything else. So if somebody has a comment that's pertinent to this meeting, you're more than welcome to say it.
No.
If not, we as
I have
a,
something to say.
okay,
His
Name?
counsel,
name,
Scott Snyder.
thank you.
Anything
I
else?
know, I'm not sure if everybody does.
Anyway,
Did you want a time limit? I'm sorry. Did you want a time limit?
no, it'll only take me a second here.
Okay.
His counsel that advised him and everything that was going on within this contract and everything, missed it.
Pardon me,
That would be him.
okay, advise
gentleman?
Bob.
Advised
Okay.
Bob that everything in there was fine. But one thing isn't fine is that turbine changed. Okay, so the council didn't catch the change of the turbine. So that falls on who, and being that is a change to what Bob said was fine, to me would negate those permits until that was looked into to find out about all the particulars when you change the size of turbines. There's so many things when you change the size of a turbine that it's not apples to apples. I bought a diesel car. I got a diesel truck. Is there a difference? There's a difference. So when there's a difference, that means that it's not the same. That's all I gotta say.
Thank you. Anybody else? If not, we will proceed with discussion amongst the board.
I do.
Okay,
I'm
I'm sorry.
Cassidy Art, and I'm speaking on behalf of my husband Dan. He was not able to come tonight, so he wrote this up and handed it to me. So, as someone who has been blindsided and caught right in the middle of this controversial chaos, I have seen firsthand how this has divided neighbors, friends, and especially family. What was described as easy money to landowners with a used car salesman technique has soon lost its luster. After seeing a close family member manipulated into signing a wind contract and the irreversible damage it has done to him with stresses of broken relationships with neighbors, tenants, and family, he is regrettably unable to revoke his wind lease. This particular family member has taught life lessons. First catchphrase that I'm often reminded of is, fool me once, shame on you, fool me twice, shame on me. I truly feel that the people and the motives behind this project only have one thing in mind, and it is their personal financial gain. I have formed this opinion due to firsthand experience of dealing with them as a tenant. There is no compromise with them to protect the soil, the farmer, or declining land values, especially with neighboring farms who did not sign any contracts, who benefit nothing and still forego to decreased land values. Do business with shady people, you'll expect shady results. As a farmer, my number one duty is to take care of the land. There is a long list of negative impacts that will permanently affect not only the landscape visually, but it will devastate soil biology, have irreversible damage to drainage systems, both existing and future. Soil simply cannot be removed and replaced and expect good results. As a 42-year-old farmer, I am always looking forward. I do not see how this will be beneficial to the next generation. We should always leave the land in better shape than when we were blessed with it. After talking to many neighbors who farm as well, the only farmers in support of this project are ones who directly benefit financially from it, or at least think that they are. Many tenants have been forced to sign cooperation agreements or lose their livelihood and leased land. I have found myself in this position, and it is a difficult one to be in, between choosing what is right for the land, knowing the landlord is regretting signing a wind energy lease and would like out of it. I have personally been threatened to be sued by Salt Creek or to sign an agreement. God made me a farmer to entrust me to be a good steward of the land, and I am choosing to not sign their devious contract at the risk of losing my livelihood. I firmly believe that if this project is truly good for the people who reside here in Tama County, there would not be so much repercussion. I think if people put the so-called easy money aside and follow true instinct and values of their heart, the answer to this problem would not be in question.
Thank you.
Hello, my name is Heather Knivel. I live in the Salt Creek Wind area. I was just elected as Tama County Supervisor for this district of Gladbrook and Traer, which pretty much includes all turbine areas. So I got Vienna area that's already built, I got the Salt Creek area, and I had where the Apex was being talked, kind of in the whole turbine area. So I know we keep talking about how the conditional use permit does not apply. Typically, let's not even talk about wind, any conditional use permit, usually they would do a building permit right after, right? So everything in the cup would flow right into the building permit. So some things like the FAA being expired. So that's something that's in the Tama County ordinance, FAA, which is your aviation, it's so, airplanes don't hit the turbines. That is supposed to be in there. It expired in May of 2024. So there's currently no FAA, which violates the Tama County ordinance. Decommissioning, so back in 2020, there was decommissioning that was put together by the company that's supposed to be building Bechtel, right? So not a third party, it was by the company that was building, and it was almost 4 years ago. We all know that inflation is hit hard, right? I mean, the rates have had to have gone up, and there's no bond for 15 years. So that means if they build these, we have a new president in as well. If the green energy goes away and these turbines are built and it's a 15 years till there's a bond of money, that puts this county at risk. And as an upcoming supervisor, I'm gonna do what's right to make sure that this county is protected, because we can't take all taxpayers down in something like this. The studies, as we already said, birds, bats, I mean, eagles, they change, right? They're not gonna always fly in the same pattern, right? So what they did 4 years ago is probably different. We have rare Indiana bats. I mean, these are things that you gotta recheck to make sure that Stantec or whoever the company is does their due diligence. The substation, it was approved by the Board of Adjustment in 2020 on a different parcel. You cannot move it to another parcel to the southeast of the current ITC when it doesn't have approval. So again, something else for you guys to look at. As a upcoming supervisor, I was elected in a big turbine area with 97%. My job is to do what the people want. It comes down to following the ordinances, which they need to be updated, they're very old, but I need to do what the people want. So I want to do a little experiment, since most people won't get to talk. If you believe that the Board of Adjustment should revoke Salt Creek's permit today, please raise your hand now. Thank you.
Any other comments?
Mike, Richard, I won't stand up.
Stand
You
up.
want, stand up.
Who do I talk to? You can talk to whoever you want to.
I just wanna make a quick comment. You guys are making a decision concerning what Bob did. That's what you've been saying all night.
Right.
Do what a jury would do, and make sure, beyond a shadow of a doubt, that what he did was perfectly legal. Think about that. Thank you.
I'd like to speak. I'm Mark Dolan. I'm also a newly elected supervisor to take over office in the 1st of January, and representing Toledo and the Garwin area. And I've been attending some meetings, and then I follow what goes on in the paper and reading all of the documentation. And I don't know what your opinion was, but when Bob was asked all of the questions by the attorney, if you couldn't tell the difference in response from the attorneys, he definitely has been orchestrated his testimony with the attorney that was advising him. And if you want to look at timelines, all of these things, when they had retracted their original conditional use permits, that timeline, and then when they got rid of those lawsuits and now had reapplied, it was a political tactic. It was a legal tactic, I guess, and that was made by a lame duck member of the Board of Supervisors, knowing that that board was going to turn over no matter what. And these ordinances are going to be updated with the new board. That's been guaranteed in the newspaper. It's going to happen starting January 1st. And so the timeline, we're really at the 11th hour between now and January 1st. I think there's about 49 days, if I did my math correctly, to get these things pushed through before the new board comes in. I don't think that we need to be in any hurry after it's been since 2009. Why does it have to be hurried through right now? So I just ask you that you take those things into consideration. The attorney asked that you had mentioned that Bob's job isn't to be an attorney. He doesn't have the training. However, he went on to define the exact responsibilities of a judge in a jury to make determinate factors of the law in the ordinance to make sure that they were insured, which he consulted with legal counsel and in turn made the determination, which is a judgment. And so, yes, his job is to be the judge in the jury.
I'm Laura Wilson. I just wanted to say, Bob said that he has 7 days to do the permit review, right? But that's 7 days per permit, so that'd be 427 days he could have spent. So spending 10 days to review something that he could have spent 427 on, that seems like a very small amount of time for the amount of time permitted to review all that information. And I know you said the cups have no bearing, but if you're basing these zoning permits on cups that had been fraudulently misrepresented, let's say, to you guys, that might be something you want to review. And there's no time limit on when you can review those cups if they haven't built anything. So I do feel that is a relevant part of this, to review the cups with the current zoning permits, especially with, like Heather said, the changes that happen. If more information has come to light that you were not provided with when you issued the cups, that could determine if these zoning permits are more or less valid than they are now. So I hope you do consider that they are linked. It's not just the zoning permits or just the cups. It's both of them together. They're two parts of a whole. So I hope you take that information into consideration when you make your decision. Thank you.
I just been studying this. It's been quite an evening.
Any other comments? If not, we as a board will start our discussion. Comments?
No. I have no other comments.
Okay.
Well, I
I know
mean,
what my discussion's gonna be.
I've gone through this thing with a fine tooth comb. I've got highlights, I've got flags, and even in my living room, on my little desktop, I was able to determine that the new certificates identify a description of a turbine. And I think even when they gave us a turbine candidate table in the cup, I think that was really outside the realm of the correct rules. I think they should have identified back then what it was gonna be. They said, maybe one of these four, and now it's number 5. It's totally different. And I just think it would set a terrible precedent if we just said, yeah, well, it's a turbine, and I'm also very concerned too, and I had also, gotta find my sheet. Oh, here, I had also printed off the, Article 20, Section 2001, the procedures for certificates, and it's been discussed, ad nauseum tonight. But I had highlighted, and it was spoken verbally tonight by someone. The applicant shall describe the uses to be established or expanded, the proposed cost of the erection, construction, or structural alteration of the building or structure, and any other information the administrative officer deems essential for the enforcement of this ordinance. To me, that, it's like, okay, they've opened the door a little bit and said, you know, bing, 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 you gotta do all these things, and if there's anything else, and so I just think that those studies, the FAA is a big one to me, and the eagles, the bats, the eagles, the avian studies, he could have said, I would like those updated. Things have changed. I mean, 4 years is a tremendous amount of time, in my mind. To just say, it was good then, it's good now. And the whole decommissioning thing is that's another realm, I mean, but, you know, we have kind of a very narrow, focus here tonight. So, I just think that the fact that the application, and the permits were for a totally different turbine, and I just think that just screws all those studies up.
Kelly, are you still there?
Yes, I'm here.
Do you have any comments?
No, I do not.
Okay, any questions?
Nope.
Can I comment on something tonight? I noticed, can I comment on something? I noticed too, along with Nancy, that, anything, I know we're just to look at the zoning permits, but if the zoning permits are being issued due to what was on the cup and how they had such a variance too of what the turbines could feed in. But I agree with Nancy, it doesn't come close, it gives a different thing than what was in the cup, and if you're getting the zoning permits due to the cup to begin with, then I don't see how that's valid.
And here again, there's been a lot of information brought forth tonight. Comments from the public, comments from the lawyers. I think we still need to focus on one thing, and that is zoning ordinance 2001. And according to what Bob did, he went according to that ordinance, dealing strictly with whether or not he issued the permits according to the zoning certificates, or to the zoning ordinance. So, that's my comments. After that, I will ask for a vote. Did Bob Vokoun issue the permits according to the ordinances in place? And I vote will say yes, and they vote will say no.
Well, could we, just to stay consistent with your rules,
Yes.
I would suggest that you make a motion to, what the rules provide is a motion to affirm, modify, or reverse.
Okay.
So I would just suggest that you make one of those motions.
I will make a motion, I will have somebody make a motion, I guess, I don't wanna make a motion since I'm the chair.
And just because you make the motion doesn't mean you can then not vote in the negative. It's the same result if you vote your conscience and what you're planning on voting.
Could you repeat that? I'm sorry.
I was waiting for you to go.
Affirm, modify, or reverse.
Legal speak, I mean, 'cause
So, just to clarify, if someone makes, it doesn't really matter if someone makes a motion to affirm or deny. It either passes or it fails. If he makes a motion to affirm, you're opposed to it, you then vote no. If it doesn't pass, it fails. Does that make sense? And usually you want to state your motions in the affirmative, so when you say yes or no, it's consistent with what you're thinking, so you're not doing a double negative type thing.
So. You're gonna make that
I've
motion?
been pretty brazen tonight, so I
Okay.
guess I'll step forward and say, I would make a motion, and the language in the appeal said reject, rescind, revoke, overturn, and now we've got reverse. So it's a lot of R's there, but I would make a motion because of the reasons that I have given. I just think it sets a terrible precedent when you, I mean,
Just make the motion.
yeah. I make a motion that we reject, rescind, revoke, or overturn, and reverse Bob's,
Decision.
decision to, assign all these certificates.
Okay. A yes vote will mean that you approve of his issuing the permits.
No, the way she's stating her motion in a negative, so a yes is a no, which was to my point. You could just as well make a motion to affirm, so it doesn't mean you're voting to affirm.
I think you have to.
So I can't make a motion that reverse.
You have to make a motion to affirm, and then if you affirm it, you say yes. If you don't affirm it, you say no. Okay? Follow
And then the
me?
yeses or no.
Yeses or no's?
3
Yes.
yeses, it's approved. 3 no's, it's rejected, even though you stated as affirm.
Could you, in your language?
Do you, yes, we wanna go that way, I mean, do you affirm that what Mr. McCoon did was legal and in accordance with the law, the zoning ordinance and the code?
But then how would I make a motion?
You can just say a motion to affirm.
A motion to
Motion.
But that's a good way of
Mr.
wrapping
McCoon's
your head
decision,
around it.
or the alternative is no.
Jack, a motion to affirm Bob Bocoon's decision to issue the permits. So if you don't want to affirm it, you say no
Okay,
on the vote,
okay,
okay?
you have that, Bob?
Everybody
I want to-
understood?
Yeah, let's make sure that Mr. Kelly has that. Kurt, you understand how they are voting? A yes, correct me if I'm wrong now. A yes vote is you are affirming that Mr. Bocoon's actions were proper and correct.
I understand that.
Okay, a no vote is saying that they were not proper and correct.
Okay, now that everyone understands that, hopefully, is there a second? I don't wanna jump on your toes, but I
No,
didn't hear
you're
a
fine,
second.
you're fine, I was good, yeah,
I'll second it.
okay, good. All in favor? Aye?
No,
No, the motion.
the motion.
The motion.
The motion, okay, all right, that's the motion, I'm sorry.
You're thinking.
Oh, Lord, let me out of
You're
here.
making it real small, they are.
Okay, I made the
Okay.
motion, I guess I better say aye to that, yeah.
Yes, okay, that's nice. Okay, motion carries. We have to
Now vote.
approve the motion, correct?
You don't need to vote on the motion, you just need you need the motion to affirm in a second.
Yes, now
And
we're
then
gonna,
you vote yes or no.
Yes.
You
now we're gonna vote.
No, you disagree.
Yes, to affirm it, agree with Bob's decision, or no,
You don't agree.
we don't agree with his decision.
There you go.
Okay, so now you have to go down to your list of all of us here, this. Oh, gotcha.
Kurt, your vote?
Yes.
Nikki?
Nay.
Nancy?
Nay.
Todd?
Yes.
Mike? Yes. Motion carries 3-2, affirming Bob Bocoon's decision to issue the work permits. I need a motion to adjourn the meeting. Thank you, Todd. I need a second. Second.
I'm sorry, who seconded it?
Nancy did.
Okay.
Meeting is adjourned. Thank you all for coming.
You didn't vote on it. You didn't vote on the adjournment. You failed to vote on the adjournment.
All in favor, say aye.
Aye. Now we're good.
Kurt, thank you for calling in.
Yeah. All right. You're right. I was hoping you would.
So I did, we're just gonna go with the rules provided for 15 days.
I'm sorry.
I would have thought that they're supposed to be non-biased, maybe except for their message.
Obviously, that's the issue. I'm sorry, I've got to.
Had 'em.